Welcome everyone to the meeting of the Subcommittee on Public Service Commission Investigation Regulation. We come to the first item on the agenda, meeting with the administration. Now we will now invite the government officials to join us. A reminder to members, before you speak, please declare any interest you have. And then there's also this matter about inviting submissions. So a question for members, do we want to invite the public and relevant bodies to provide submissions on this regulation? If so, then we can invite public submissions or we can hold a public hearing. Mr. Chao Siu-chung. This is a matter of concern to the public and to the civil service at large. We should invite written submissions from civil service trade unions and also members of the public who take an interest in the matter for our reference. What about other members? If not, we will adopt Mr. Chao's idea, so we will invite written submissions from the public. The Secretariat will put up a notice on the LegCo website. We will also let district councillors across the city know how the public can submit the submissions. We will now start the discussion on the policy aspect of this regulation. We will now invite Mrs. Ingrid Yang, Secretary for the Civil Service, to brief members on the specifics of the regulation. Members who wish to speak, please press the request to speak button. Let's do 4 minutes question and answer inclusive for each member. I will now read out the list of members waiting to speak. Mr. Chao will be the first one to speak, and then Mr. Chan Chou-Kwang, Mr. Wu Yingpeng, Dr. Thomas So, Mr. Kingsley Wong, Mr. Lam Chen-Sing, Mr. Dennis Leung, Mr. Ken Wong, Mr. Aaron Bok, Ms. Carmen Khan, followed by Mr. Augustine Wong. First, over to the Secretary, who will brief us on the paper. Thank you. Improving the efficiency and effectiveness of government departments in executing government policies and measures is a policy highlight of the current term government. At the same time, we have been promoting dedication, commitment, and a sense of responsibility among the civil service. In light of this, the Chief Executive's policy address last year proposed a heads of department accountability system and also the investigation system. We will now call this the administrative responsibility two-tier investigation mechanism. So simply put, heads of department will have to take responsibility for the performance of the department. This is to enhance the execution capability and also efficiency and efficacy of each department. We will also want to enhance administrative accountability and clarify the responsibility of civil servants in managerial roles. On the 28th of April this year, at the meeting of the panel on public service, I briefed members on the concept of administrative accountability and also the administrative responsibility two-tier investigation mechanism, as well as the highlights of the Public Service Commission investigation regulation. Members generally supporting this idea. So this concept will be triggered by a problem that is identified. If the problem is serious, if it is widespread, repetitive, and systemic in nature, or there are signs showing that the head of department or the permanent secretary is implicated, then a Tier 2 investigation can be triggered. For such investigation, it will be conducted by the Independent Public Service Commission, and that will result in greater credibility. The investigation will cover everyone involved, irrespective of their rank. Right now, the Public Service Commission does not have any investigative function. To provide the legal basis for this investigation team of the PSC, we will have to make this regulation under Section 14 of the PSCO. In making this regulation, we have to be sure that we expand the functions of the PSC so that the investigation team can conduct Tier 2 investigations effectively. we have to strike a proper balance between impartiality and the efficiency of investigation. The main provisions of this regulation contain first, Section 1, the commencement date, Section 3, which is about the referral of problem for investigation, and the mechanism to trigger such an investigation. Section 4 provides that the PSC must conduct an investigation upon referral. Section 5 provides for the formation of the investigation team. Section 6 provides for the investigative functions. Section 7 sets out the procedures of investigations. Section 8 sets out the requirement that the investigation team must prepare a report of its findings and advice for submission. And then the report and findings will be submitted to the Chief Executive, the Secretary of Department, their deputy, or the Director of Bureau. With LegCo support, this regulation will take effect on the 17th of July this year. As I said time and again, the investigation mechanism is there to be triggered when needed. If a department is performing well, they will be able to avoid widespread, systemic, repetitive, or serious problems. So we will rarely have to resort to this investigation mechanism. With the implementation of this investigation system and also the two-tier responsibility system, we will be able to enhance departmental efficiency so that we can promote this service-oriented culture for the civil service, and civil servants can enhance their professional image of serving the public. I will stop here. Thank you. Now, I open the floor for questions. Mr. Chao Siu-chung. This regulation will institutionalize and clarify administrative accountability. I support this. To implement this accountability system, we will have to make this regulation, that is the Public Service Commission investigation regulation, so that the PSC will be empowered to investigate matters. So we should focus on this point today. I have some questions for the Secretary. The Secretary explained this point at the panel discussion. We discussed what is meant by a serious problem. When a serious problem occurs, a Tier 2 investigation will be conducted. I hope the Secretary can clarify this point. What do we mean by a serious problem? Can we have some examples? The Chief Executive and SODs can also trigger an investigation, even if the problem is not widespread, repetitive, as long as it is something involving a single head of department. So does it mean that a single problem will give the Chief Executive and SODs the power to start an investigation? My next point has to do with the terms of reference of the investigation team. If a new problem is uncovered during an investigation, or there is other evidence to this effect, the terms of reference can be amended so that the scope can be expanded and more people can be investigated. Or maybe the terms of reference can be reduced during an investigation. So my question is, when do we amend the TOR? Those are my questions. First, the question of what is meant by a serious problem. It is what the average person sees as a serious problem. It will be hard to give a specific example, but I can say that it's not some sort of careless mistake or an indiscreet remark. It will be a problem that has a major impact affecting many people of widespread public concern. Now, is a one-off mistake by a head of department enough to trigger an investigation? It depends on whether the public sees this is something that causes a major impact. If it's just a one-off minor mistake, that's fine. But if it's a major issue, then a one-off mistake means that the CE, the SODs, and DSODs will be able to start an investigation on the terms of reference. As you can imagine, we see a problem, we start investigating, and then halfway through the investigation, we realize the scope of the problem is bigger than we thought, or more departments have to be investigated. Or it can be the other way. The problem turns out to be less serious than we thought. When we see this change halfway through the investigation, we will have to expand or shrink the terms of reference. This may happen, and that may warrant a change to the terms of reference. No follow-up. Next, Mr. Chen Shoukwang. Thank you. I fully support this regime, but I have a comment. On the investigation team, there will be support staff members, and those staff members may come from the department involved in an investigation, because those will be people who are familiar with the operation. So you end up with the impression that you have peers investigating their own peers, and that may cause a perception issue. Would that be a conflict of roles, Secretary? We will not appoint officers who work with the subjects of his investigation as supporting staff members. Now, take the logistics department. When we were investigating the matter about the bottled water incident, that wasn't an investigation conducted by the PSC, but we enlisted the help of officers who had nothing to do with the procurement work of the GLD. Mr. Wu Yingpeng. The two-tier investigation mechanism can enhance administrative efficiency and efficacy. I support this regulation. I have a question about Section 7, Subsection 4. Solicitors and counsel, in general speaking, do not have the right of audience at meetings of the investigation team. And where appropriate, counsel and solicitors will be able to speak. But the report of the investigation team may lead to retirement in the public interest or dismissal for a civil servant. So my question is, when will we allow solicitors and counsel to attend meetings of the investigation team? When will that be appropriate, Secretary? For the investigation team of the PSC, we investigate matters too, but now we simply appoint civil servants unrelated to the matter, and usually seniors and usually civil servants who are more senior in rank, to conduct the investigation. It's an internal procedure. There is no criminal element. It's not about pointing fingers. It's about finding facts. And then the report is compiled. The report goes to the official concerned. The bureau involved will then read the report, showing the outcome. Maybe the report reviews someone did not do their job, maybe there is incompetence, or maybe there is misconduct. When that is the case, we have a performance management mechanism. There's also the disciplinary mechanism. If it is a disciplinary mechanism, in the formal sense, there will be a hearing. At the hearing, the civil servant involved will be able to appoint a legal representative to appear on their behalf. That's when we decide whether penalties will be imposed, maybe dismissal, maybe demotion. The investigation itself is purely about fact-finding. With that in mind, in line with our current practice, we simply hire a more senior civil servant to investigate the point. The same practice will continue in the future, so no counsel is involved. But if the lack of legal representation gives rise to injustice, then we can allow the appearance of a solicitor or counsel. It is hard to exhaust all examples. Say you have a civil servant who is seriously ill, they cannot speak, and we will need someone who can articulate the civil servant's wishes. That may be a reason for appointing counsel. We cannot exhaust all possible scenarios here.
Next, Mr. Thomas So. Thank you, Madam Chair. First of all, I'd like to say that I support the regulation. How can we make it more convenient and more for the administration to uncover problems? The design of the mechanism should be done in such a way that the goals can be met. I'd like to follow up on what Mr. Wu said. I understand that due to certain reasons, civil servants may try to withhold information. They may suspect that their seniors have violated certain regulations, and they may withhold certain evidence of their committing crimes. And sometimes they may not know whether they should submit certain information, because if they do so, they may be self-discriminating. I think that we should allow civil servants to seek legal advice. We may not allow them to have an audience before an investigation team, but I think that we should allow civil servants to seek legal advice as to whether or not they should answer certain questions put by the investigation team. That's a question about legal representative and their role they play in the course of investigation. In paragraph 13A of your paper, it is said that the investigation team can require any person to do A, B, C, D, E, so on and so forth. People outside of civil service may be involved in the investigation, say, for example, contractors. If one is a civil servant, if they does not cooperate, then they may violate the relevant regulation. But what about the contractors engaged by the government? These are my two questions. Secretary. Thank you. Mr. So said, during the course of investigation, civil servants need to cooperate. It is their duty. We are going to explain very clearly to the civil servants that they have the duty to cooperate with the investigation team, and they need to submit all information required by the investigation team. There should not be any hiding. That's their duty. Investigation team may ask the civil servants questions in writing. If the information required is not confidential, then civil servants are free to seek legal advice or advice from other people. We don't have any objection to that. But if the information required is confidential, then before they seek any advice, they need to seek approval from their seniors. If we're talking about in-person meeting, the civil servants need to submit all they know to the investigation team. We are of the view that this is the duty of a civil servant. Regarding the words any person, we understand that if people outside of civil service is involved, they may not cooperate with the investigation team. If they are not willing to work with the team, then the team of the PSC can only base their investigation that they're able to collect from the relevant persons before they make a judgment. Because after all, the investigation involved is not criminal in nature. I'd like to stress again that the mechanism is this same as what we have now, because currently we are just asking a senior civil servant to investigate. Now, having this mechanism, we try to make the entire thing more credible. We may not force people not within the civil servants to submit all information they have. We can only base our judgment based on what they are willing to provide. Mr. Lam Chen-sing, thank you. And last time, the Secretary have clarified about what issues will be covered by the mechanism. Second, we always say that the justice that comes late is injustice. Regarding the bottled water incident, the investigation took some 3 months' time. The Secretary said that generally, investigation will be completed in 3 months' time. Should we not set a indicator such that there will not be any investigation that lasts years? Second, we try to encourage civil servants to be proactive, but as the society changes rapidly, many civil servants are very conservative. They try to avoid mistakes. And as a result, creativity and innovation are hindered. I think that we need to allow people to make mistakes. For civil servants who try to be innovative, they may make mistakes along the way. How do we encourage that? Secretary. Thank you. We hope the investigation will be efficient, and we hope that we'll be able to find facts. Different incident is of different nature, and the time taken for investigation may be different. And that's why we won't want to set a target or deadline. But the chief executive, the SOD, Deputy SOD, and DOB may set a time limit for investigation. And I think that the time can be set when the investigation is triggered. Second, we are not trying to investigate all sorts of mistakes. As Mr. Wang said, we try to encourage civil servants to be creative, to be innovative. Civil servants may try to reform some of their process, use new technology, try to be creative. If the decision is reached through thorough discussion within the department and risk assessment, and if it's well recorded, and then mistakes happen, then we can learn from them. It doesn't mean that as long as there's problems, there's issues, we investigate against them. We ask our colleagues to be cautious in what they do, but we do allow for mistakes. Mr. Lam Chen-sing, thank you. If civil servants are uncooperative, if they don't attend the hearing, what is the consequences? Some civil servants may be demoted, they may be forced to retire upon investigation. If only warning is issued, if for civil servants who refuse to attend the meeting or submit information, will that encourage them not to be cooperative? Second, for reasons of privacy or protection of personal data, government says that they're not going to publish the report of investigation. Does the government have discretion as to decide whether or not a report should be published after balancing factors such as privacy, along others? Maybe they can disclose more information in the PSC annual report. Third, for the Wanfo Court fire, we have established an independent committee. Many heads of departments went to testify in the hearings. If after the investigation we want to hold certain civil servants liable, are we going to invoke the disciplinary procedures, or do we have to go through this PSC investigation procedures? If there are similar incidents arising in the future, what would the roles of the government be? Should we establish an independent committee, or should we ask the PSC investigation team to investigate? Secretary. Thank you. If civil servants are uncooperative, then they are not fulfilling their duty, and they're not complying with the seniors' instructions. The consequences can be severe, depending on the extent of uncooperativeness. If they try to delay things, if they refuse to attend meetings, then they may have their increment paused, they may be demoted, and they may be subject to disciplinary action. Second, for serious matters of community concern, the SOD, Deputy SOD, DOB who activated the investigation will answer people's questions. The reason why we mention privacy is because business sensitive information, trade secrets, confidential information of the government may be involved. It may not be suitable for us to publish the entire reports due to those reasons. But I believe that officials involved will disclose the result of the investigation as appropriate. Regarding the Wanfo Court fire, let me explain it more clearly. The disciplinary mechanism is about individual responsibility. If a department underperforms in certain areas, we have to identify who is responsible. Regarding the independent committee on Wanfo Court fire, well, after the report is published, should we invoke the disciplinary mechanism? Well, that depends on whether we can identify a single civil servant who should be held liable if there is any misconduct. If there is any misconduct on the level of individual civil servants, then we may trigger the disciplinary mechanism. If not, we may have to do more. Thank you.
Mr. Dennis Low. Thank you. there are orders and regulations governing civil servants when it comes to making mistakes and disciplinary matters, and that includes the Public Service Administration Order and the Public Service Disciplinary Regulation. And then there are ordinances governing the discipline services, and then there's also the Civil Service Code, among other regulations. So my question is, should we spell out things with greater clarity in other regulations and codes for the civil service? When we get to the disciplinary procedure, the civil servants involved may refer to the other regulations governing the civil service. So I think you should spell out the provisions more clearly. I wonder if this was considered in the making of this regulation. And then I'm looking at Section 5 of the regulation. It's the formation of the team. Section 5, subsection 2. It takes just 2 members to constitute the investigation team. Why not 3 members? When you have to reach a decision, having 3 people can help you decide things. So you can someone may disagree, but then this person can be overridden by 2. I have to declare an interest. A family member of mine is a civil servant. Secretary. The member referred to the Public Service Administration Order. And there's a separate disciplinary regime for certain ranks of the disciplined services. Those documents set out the disciplinary procedures, the penalties, and where the power to discipline them comes from. Now we're still talking about investigation, meaning the stage before the disciplinary procedure. First, we find out what happened, who's involved, to what extent is this person involved, the gravity of the matter, and the extent of this person's responsibility. So we're talking about something before the disciplinary stage. We go through the investigation and then we worry about the disciplinary procedure. When it's the formal disciplinary procedure, there's the hearing, the decision, and then the penalty. So we're talking about 2 stages. Now we're making this regulation, the Public Service Commission Investigation Regulation. Making this regulation will not affect the Public Service Administration Order and the other forms of subsidiary legislation for the disciplined services. Now, the formation. We need at least 2 members. That's the minimum. We're not saying it has to be 2 members only. It depends on the gravity or complexity of the matter. So the chairperson of the PSC will decide on a case-by-case basis. Mr. Ken Wong. I want to write on the point raised by Mr. Kingsley Wong. It's about the investigation. The Secretary said different time limits may apply depending on the circumstances of each case. I support that. But when we see delay, someone's stalling out the process, is there a more effective way for us to pursue the investigation? The paper says the investigation team will also consist of support staff. Are we going to specify the rank of the supporting staff? Will we appoint officers at different ranks depending on the fact of the case? Secretary. The PSC has no incentive to stall out the case. The chief executive and other principal officials entrust the PSC with investigation. There is no incentive for the PSC to stall out the case. They have to get the work done. Now, on the subject of the investigation, or someone who is requested to provide information and then this person stalls the process, If it is a civil servant, then as I said in my reply to Dr. Thomas So, we will let this civil servant know and we will make this clear that cooperation with the investigation team is their duty. That should be seen as part of their work. They should provide the information in a speedy way and in full. If they fail to cooperate, then that will be their dereliction of duty and that will lead to a disciplinary penalty. So we're not very worried about serious delays. There is a mechanism to deal with delay on the part of the subject of investigation. Now, the supporting staff. Mr. Wong made a good point. Appointing the supporting staff really depends on the facts of each case. When there's a need to set up a team, we look at the nature of the incident. We look at the department or policy bureau involved, and then we decide how many support staff members, and then we decide on the ranks and the areas of expertise we need. Next, Mr. Aaron Bok. I declare an interest. I'm a retired civil servant. I have friends who may be senior civil servants or directorate civil servants. I support this regulation. The regulation is welcome, but I have a concern, and that is overcorrection or good intentions leading to bad outcomes. As the Secretary said, we should tolerate errors to a certain extent. Section 3 ABC state that when these things happen, an investigation starts. So that's the law. But the Secretary also said things that amounted to an administrative decision. So will there be a Civil Service Bureau circular in the future setting out the cases that have to be true before an investigation starts? Now, on the decision making, the paper is silent on when the team will make a decision. I'm looking at Section 3, Subsection 2 of Cap 93. It says that this is for the PSC as a whole. The PSC has to secure the unanimous decision of the chairperson and all members who vote before they can make a decision. So my question is, for this investigation team, do we need a unanimous decision? Will that provision under the PSCO also govern the work of the investigation team? So the question is about when this mechanism will be triggered. After the policy address was delivered last year, and also after I briefed the panel on this point, I explained the matter. So this point is clear. A trivial matter, a trivial mistake will not trigger this investigation mechanism. It's hard to give specific examples. We cannot imagine what will happen if I give you examples A, B, and C, but then new scenarios may come up. Secretary, can we write into the circular this encouragement of, or rather toleration of errors as a culture? Secretary, if civil servants have concerns, they can talk to their head of department or management. It's about making sense. It's about a sensible approach. We look at all the facts, and then we take a calculated risk. This applies not just at the departmental level, but also at an even higher level. You decide whether it's worth it to take the calculated risk. If a civil servant fails to consult their superior and then proceeds to the work, that may be a problem. But again, we have to look at the gravity of the matter, whether the action is sensible. So again, it's about whether the action taken is sensible. So we will explain this point to departmental staff. Now, on whether a unanimous decision is needed from the investigation team, under Section 3, Subsection 2 of the PSCO, the chairman and not less than one member may exercise and perform any of the functions, powers, and duties of the commission. The PSC deals with questions of promotion, recruitment. They follow this procedure. They don't need everybody to be at the table. They simply need the agreement and support of a certain number of members there. We have sought legal advice on this, and this approach is prudent. Ms. Carmen Khan. The 2025 policy address proposed the HOD accountability system. It is about enhancing the credibility of the investigation mechanism. As the Secretary said, we now have the performance management system. There's already an investigation mechanism for maladministration. Now we want greater credibility. So we are empowering the PSC to investigate cases. That's why we are making this regulation. Let's cite an example. If the procurement of the bottled water happens after this regulation is made, will a Tier 2 investigation be triggered? Illustrating the point with an example will give us greater clarity. With this regulation, we will have a more independent body, meaning the PSC, to investigate the point. Now, I also want to check my understanding. We're talking about an investigation regulation. There will be 2 tiers to the investigation. That will have no bearing on how you discipline civil servants. We're not amending the PSAO or the PSDR. First to investigate, and then the matter moves on to the disciplinary mechanism. The concern about legal representation. At the disciplinary stage, the civil servant will be able to obtain legal representation. For the investigation, we're simply continuing the approach of an internal investigation. It's simply that we want greater credibility. The director of bureau, an SOD, a DSOD, and the chief executive can trigger an investigation. Having the PSC investigate the matter will simply give rise to greater credibility. Is that the whole point? Secretary. Now, for the incident involving the GLD procuring bottled water last year, I was not the official in charge. I did not ask whether the incident was serious enough. For this incident, the government had to respond to the matter in public, and then the government briefed everyone on the outcome. This sounds serious. If something similar happens after this regulation is made, it's possible that this investigation mechanism will be triggered. And Ms. Khan is right on her second point. When something goes wrong, we investigate the matter. It is an investigation of an internal nature. We find out the reason. We usually find a more senior civil servant to investigate the matter right now. But in the future, we want greater credibility. So the principal official will get the PSC to investigate the incident. This regulation will empower the PSC to investigate the case. The regulation will set out the powers of the PSC and how the investigation should be conducted. Investigations are being conducted now. It's simply that there will be some difference in how the public sees it. Mr. Augustine Wong.
有個意見。
Thank you. Well, the investigation team can engage independent experts. Can you clarify if these experts are members of the team? Do they have any power to make a decision? Is it the case that they can only offer their advice? Can you clarify it? Second, it is said that the investigation team can require any person to produce information, so on and so forth. By any person, we mean people who are not civil servants. According to Section 9 of the Principal Ordinance, if someone offers misinformation, then there is penalty. Now, in the regulation, we only require civil servants to cooperate. As we empower the investigation team to conduct investigation, if someone does not comply with them, then there is no penalty or consequences. I think that the secretary needs to explain why there is no penalty. If yes, will we make reference to Section 9 of the Principal Ordinance? Thank you. Secretary. Mr. Wong's understanding is correct. Independent experts will not be members of the investigation team. They only offer their expert opinion to the team. The investigation team will form an opinion on what happened on the day of the incident. Experts will not take part in the decision-making process. They only offer their professional opinion on areas of their expertise. Section 9 of the Principal Ordinance will apply during the investigation defined in the regulation. Anyone, regardless of whether or not they're civil servants, if they give false information, will be in violation of Section 9. Why is there no consequence to that? Well, according to the PSCO, there is no provision forcing anyone to produce information or answer questions. As the regulation is an extension to the Principal Ordinance, we are of the view that we should not empower the investigation team to the extent that their rights override that of the PSC. To answer Mr. Wong's question, as this investigation is not a criminal in nature, is not a legal proceedings, we need to strike a balance. Mr. Chong Ho-feng. Thank you, Chairman. I'd like to clarify something. According to paragraph 15, it is said that the persons related to the case under investigation should make oral or written statements as the investigation team considers appropriate. Is the oral or written statements mandatory? If they refuse to make statements, will there be consequences? Regulation 7, bracket 3 says that the person under investigation can answer questions. So I wonder if the statement making requirement is mandatory or not. Secretary. As I said, the investigation set out in the regulation is not criminal in nature, is not part of legal proceedings. is just a fact-finding process of the government. So the investigation team does not have the power that is equivalent to that of the law enforcement agencies. The subjects on investigation are mostly civil servants. We'll state clearly to the civil servants in question that cooperating with the investigation team is part of their duty. They need to cooperate and they need to disclose all that they know accurately to the investigation team, just like how they carry out their duties at work. If they choose to disclose only part of the truth, if they give false information, if they deliberately delay the production of information, then that's equivalent to misconduct or underperforming. In the paper, you said that the persons should, and in the regulation, you said that they can. Should we align the wordings? Maybe we can look into it during the clause-by-clause examination. Mr. Chris Yip. Thank you, Madam Chair. I support the proposed amendment, but I have a question. And I'd like to seek clarifications on a scenario. Regarding the new two-tier investigation team, if an investigation upon investigation is found not guilty, that is, in the sense that they don't have to be subject to disciplinary action. If the civil servant is aggrieved by the penalty, is there an appeal mechanism? That is, if the civil servants, although they are not subject to disciplinary action, they are issued written or verbal warning. It is not set out in the paper. Second, Mr. Khan just talked about the bottled water incident. Civil servants, public money are involved. This may not have a direct impact on the public. Recently, the Education Bureau sent out the primary one allocation notice prematurely. This is a failure on the part of the Education Bureau. If the Tier 2 investigation mechanism is to be invoked against the education, well, if the regulation has already come into operation, will the Tier 2 investigation mechanism be invoked against the Education Bureau? Secretary. In the proposed regulation, we set out clearly that if part of the report published by the Investigation Bureau involve criticism against certain organizations or cause negative impact to certain individuals, then before the submission of the report, the team will have to send the report to the individuals or organizations impacted so that they can give a response. Second, the mechanism is a fact-finding process, is an internal investigation. As to how the civil servants will be penalized, maybe they will receive a poor gradings in their appraisal report, or maybe they will be asked to up their performance during a certain period of time, or maybe they will be subject to disciplinary action. Under the performance management mechanism or the disciplinary mechanism, we allow civil servants to express their views. If the relevant civil servants is aggrieved by the decision, if they disagree with the assessment of the team, then they can write to us. The department, the head of department will be the one to decide on the final decision as to what the assessment will be. As for the disciplinary mechanism, is a formal procedures. The civil servants will subject to a hearing. They will have ample time to speak up. If it's just about a warning, they still can voice their opinions to the head of department. If they are just given a reminder and if they don't agree with the relevant reminder, then they can still speak up to their seniors, their supervisors, or the person who gave them the reminder. Thank you. I think that there's an misunderstanding regarding the written or verbal warning that I talked about. I was talking about the ones that have already been issued. The warning may affect the promotion or hiring of a certain person. Given the fact that there is no disciplinary action, will they have the opportunity to overturn the warning? That's what I meant, Secretary. Let me talk about the investigation process. After it's completed, colleagues who may be criticized or may be affected will have the opportunity to respond to the investigation team before the report is submitted. As to whether or not the investigation team accept the explanation, that's up to them. The principal officials in charge may be of the view that the relevant civil servants will have to be subject to summary disciplinary procedures. Well, that depends. There is a way for civil servants to express their views within the government. They can tell their story. What about the second question? The question on the Education Bureau. Similarly, I've not talked to the Secretary for Education. I don't know if she thinks that this is a serious issue. Sometimes the issue may be simpler. Sometimes the problems may arise because certain colleagues is not being careful. It could be because some colleagues made a mistake. So sometimes we may not have to trigger the mechanism because the problem can be very straightforward. Dr. Junis Ho. Thank you. I have no problem with the regulation, but I have questions regarding the schedule, timing of the investigation. The paper talks about how the report should be prepared, the composition of the investigation team. What about the timing of the investigation? When should we start the investigation upon receipt of complaint, and after the investigation is started, within what time should the report be prepared? If a hearing is to be convened, when would it happen? It is said in the proposed regulation that there may not necessarily be a hearing. Is there a timetable? Secretary, well, the nature and complexity of different investigation vary, so we are not proposing to set a deadline for investigation. I believe that the principal official who triggered the Tier 2 investigation will, apart from setting the term of reference of the investigation team, will ask the team to complete the investigation in a certain period of time. If during the investigation we found that the matter is more complex or more simple than it was originally thought, then we may change the timetable, but there will be a time limit for how long the investigation can take. Let me give you an example. Last year, the logistics department bottled water procurement incident. At that time, we didn't have the proposed mechanism. We invited a senior official to investigate. We did set a time frame for investigation, which was 2 months. Usually, when we initiate an investigation, we do have a timetable for the investigators. Second, In the regulation, it is said that no hearing will be convened when a serious incident happens. Any organization will launch an investigation, but sometimes hearing is not necessary. But if we find misconduct among our colleagues, then we may trigger the disciplinary mechanism. And if the mechanism is triggered, then we will convene hearing. By then, the relevant colleague will have the right to engage a legal representative. They may make representation. They may engage a witness. Thank you.
Madam Chair, I still have some questions. This is exactly what we have to consider. Now, in medical negligence, a case can drag on for more than a decade. Justice delayed is justice denied. Now we're dealing with the civil service. People have to follow all kinds of rules, their internal memos. So let's talk about the investigation. It shouldn't be that hard for the investigation to conclude by a certain time. And then the report comes out, you decide whether to discipline the civil servant. That's a separate matter. But you should commit to some sort of timeline for the investigation. Let's say conclude the investigation in 3 months. Why can this not be done? I expect greater efficiency for this regulation. Of course, each case is unique. Civil servants have a well-defined scope of work, so I hope there can be a clear deadline for the investigation stage. Any response from the Secretary? As I said in my reply to other members, there's no incentive for PSC members to stall an investigation. For the subject of investigation, they will be instructed to cooperate with the investigation. Non-cooperation is a form of problematic conduct. We don't see any room for delays. The chief executive appoints PSC members. If the PSC members fail to do their job, then the CE may decide not to appoint those members again. So I don't see any incentive to stall a case. Now, speaking for the second round, Mr. Shao Siu-chung. I want to return to the TOR of the investigation team. If new evidence emerges during the investigation team can talk to the chief executive or the SOD to expand the TOR. How will the chief executive and other principal officials learn of the new development during the investigation? I don't see any requirement about the PSC members investigating the matter, updating the principal officials on the work. Should we include the requirement about reporting the interim results to the SOD, DSOD, so that principal officials can expand the scope of the work? If the investigation team expands the scope of investigation on their own initiative, in that case, can the civil servant under investigation choose not to cooperate? If the investigation leads to conclusions involving officials beyond the scope of investigation, will the government treat such an investigation as invalid? Secretary. Do we include a requirement in the regulation for the PSC's investigation team to update officials about the progress? When the PSC team sees matters beyond their terms of reference, then it should be obvious. The investigation team is tasked with investigating a matter, and then the scope of the matter turns out to be wider than expected, and then they're held back by the terms of reference. In that case, no effective investigation can continue. So they will have to report the matter. So you don't have to worry about the investigation team not reporting the matter. Because in that case, the investigation team will not be able to produce results. So the CE and the SODs, the DSODs will be able to amend the terms of reference. So the requirements in the regulation are sensible. Now, what if the investigation team expands the TOR on their own initiative? Can the civil servant involved choose not to cooperate? If the civil servant under investigation has questions about the investigation, that civil servant should seek instructions from their own superior or management, and the management will talk to the principal official involved. The official will make a decision. So if a civil servant is in doubt, they should seek instruction from their superiors. That's the best approach. Now, if the investigation team wants to say something about officials beyond the TOR, under Section 4, Subsection 3 of the proposed regulation, there's a requirement saying that the investigation team has to stay within their terms of reference. So they cannot go beyond the scope set out in the terms of reference. Next, Ms. Carmen Khan. I want to comment on the incident involving bottled water. If that incident happens after the regulation is made, whether Tier 2 investigations may start, I welcome the Secretary's response. The Secretary wasn't involved in the investigation, but she was minded to start the investigation. I welcome that response. Otherwise, we wonder if this regulation simply does not go far enough. It's about enhancing administrative accountability. So the problem has to be serious, or it's widespread, repetitive, or systemic, or there are signs showing the head of department or permanent secretary is implicated. So any one of the three conditions is true, and then the investigation starts. Now we're talking about subsidiary legislation LN 51. What do we do about Cap 93, the principal ordinance? The PSCO was made a long time ago. Some provisions under the PSCO may warrant changes given we're empowering the investigation teams. So I'm thinking about provisions such as who can serve as the chairperson of the PSC. Section 4 of the PSCO imposes restrictions. LegCo members, for example, cannot serve as PSC chairmen or members. Civil servants on pensions, meaning those who are still collecting pension payments, cannot serve as PSC chairmen and members. So there are restrictions on who can serve on the PSC. I talked to the secretary about this. After all, for the appointment to the PSC, public money is involved. It's possible to appoint a judge of the CFI. So maybe the secretary can explain Section 4 of the PSCO to us. Who can serve as a PSC chairman and member, and should we amend Section 4 of the PSCO? These people get paid after the PSC chairman gets paid, but the PSC members do not get paid. Since we're giving them more work to do, should we change the remuneration? Section 3, subsection 6 simply says the chief executive appoints the chairperson of the PSC. The chief executive can consider that when they're appointing the chairman, but the same does not apply to the PSC members. Secretary, on who can serve as the PSC chairperson, LegCo members cannot serve in this capacity. Now, for serving civil servants, they cannot serve as the PSC chairman, but retired civil servants can serve as the PSC chairperson. We did appoint retired civil servants to chair the PSC. In the future, retired civil servants will not be on pensionable terms. In the future, serving civil servants will not be on pension terms, they will be on the CSPF, so we will be reviewing how we can incorporate that into the ordinance. On the remuneration, the chairperson of the PSC gets emolument, but the PSC members don't get the same treatment. The chairperson of the PSC is a full-time job. There's an employment contract. The chairperson has to work on a full-time basis in the capacity of the PSC chairperson. Every case of appointment, recruitment, promotion will require the chairperson's involvement. The PSCO says the PSC chairperson plus one member will be able to perform the functions of the PSC. We cannot always get everyone on the PSC to sit down together. So there are panels on the PSC. They look at different matters. For every panel, for every case, the chairperson of the PSC has to be there. The chairperson also oversees the work of the PSC Secretariat. There were many paper-based reports involving promotion. Those appraisal reports and reports were sent to the PSC in boxes. Now we're adopting electronic copies instead. So that's an example of the PSC chairperson improving the work of the Secretariat. Being the PSC chairperson is a full-time job, so the chairperson gets paid. The members do not work on a full-time basis. They look at some of the cases, but not all. That's why there's a difference in their emolument. For other members of the PSC, if more requirements apply to them to the extent that the members have to put in much more time and energy so that it's almost like a job, we will then be considering remuneration, but we haven't got there yet. I'm not calling for remuneration for the PSC members. My point is that the PSCO has been around for quite a while. There are restrictions on who can serve as the chairperson. We'll be seeing fewer and fewer retired civil servants on pensionable terms. Other requirements under the PSCO may affect the regulation. The chairperson and at least one member will be able to fulfill the relevant functions. Just then, Mr. Dennis Leung asked, why not say the chairperson plus at least two other members? That's because the principal legislation only requires the chairperson plus one member. So the principal ordinance sets out the parameters. We have to stay within the framework of the ordinance itself. We cannot go beyond the ordinance when we make the regulation. The Secretary promised to review the ordinance from time to time. I welcome that position. Can I ask a further question? Can you be brief with your third question? I think the legal advisor for assisting members by writing to the government with questions, and then the government replied. There's a question about the investigation report. The legal advisor's question is that the Ombudsman's reports are normally made public. The government's reply is that the investigation team's functions are different from that of the Ombudsman. So can the government tell us? I'm looking at the reply. I think the meaning is that the Ombudsman looks at things at the departmental level, whereas the investigation team goes through the internal procedure. The investigation team will look at what caused the problem. They also look at who is responsible for the problem. So that is different from the Ombudsman's report. The Ombudsman looks at the department as a whole and looks at ways to improve the administration. So is that the reason that the investigation team's report may not be suitable for public disclosure?
Secretary, Ms. Khan's understanding is correct. Ombudsman identify maladministration and investigate into it. Ombudsman very rarely target individual officials and ask them to be held liable. For the investigation team under PSC, they will identify the person to be held liable. They will identify the nature of the problem and see if it's misconduct, if it's just incompetence, and so on and so forth. So in the investigation report, much privacy, confidential information within the government may be involved. So we're of the view that it may not be suitable for us to disclose the entire report. But as I said, if the incident involved is of public concern, if it's more serious, then the relevant principal officers will definitely announce the result of the investigation. Any policy-related questions? If not, we can go into clause-by-clause examination. If necessary, I will ask legal advisor to remind members of the drafting and legal issues. As usual, we're going to scrutinize the Chinese version first, and then we will ask the legal advisor to look into the English version of the draft. The legal Services Division have written to the government papers CB bracket 3639 2026 bracket 01. The reply is set out in CB bracket 3639 2026 bracket 01. Regarding questions raised by the legal advisor, the administration should address them during the clause-by-clause examination. Would the administration please lead us in the clause-by-clause examination of the regulation? Thank you. I will ask Ms. Shirley Lau, Deputy Secretary for the Civil Service, to lead us in the clause-by-clause scrutiny. Thank you. First, commencement. The Public Service Commission, can you speak into the microphone? Madam Chair, Regulation 1, commencement. The Public Service Commission investigation. Sorry, we cannot really hear you. Can the technician increase the volume of the microphone? Thank you. Regulation 1, commencement. It sets out that the Public Service Commission investigation regulation will come into operation on the 17th of July 2026. Any questions? If not, I have a question. As said, the regulation will come into operation on the 17th of July 2026. What about the incidents happened before that date? Is there a retrospective effect to this regulation? Madam Chair, I will answer this question. Well, it depends on when the incident happened. As I said, when problems arise, the government usually launch investigation immediately. If the problem arise after the 17th of July 2026, and if we've never investigated into the case, and if the problem is a serious, widespread, systemic, repetitive, then we will invoke the mechanism. It doesn't mean that the incident will only trigger the mechanism for incidents happen after the commencement date. We can investigate into matters that happen before the 17th of July 2026. Yes, as long as the matter has never been investigated into. If the problem have already happened before the date, then we would have already investigated into it, triggering the current mechanism. If we only found that there is a problem with the incident happening before the commencement date, then we'll still investigate into it. Ms. Carmen Khan, have questions? Thank you. I share your concern. I'm glad to hear what the Secretary said just now, that upon the regulation coming into operation, then the PSC will be empowered to invoke the Tier 2 investigation mechanism. Regarding the scope of matters that they can investigate into, PSC can investigate into matters that happen before the commencement date. I think that the Chief Executive want to enhance the responsibility system by amending the ordinance and by making this regulation. Well, I have questions regarding Clause 3. For widespread, repetitive, systemic problems or matters that involve head of department, we may only uncover the problem after the commencement date. If the mechanism can only be triggered for matters happen after the 17th of July, then matters such as Wenful Court will not be able to be addressed. Secretary, as I said, if the thing happened after the commencement date, then of course we will trigger the mechanism to investigate into it. Of course, we also have to look at whether the matter meet the conditions in Clause 3. For long-standing problems within the department, and if it's only uncovered after the commencement date, still we can investigate into it using the Tier 2 mechanism. Well, I think that the Secretary need to clarify in the regulation that as long as the problem meet the conditions set out in Clause 3, Bracket 3, then regardless of whether when it happens, we can still trigger the Tier 2 mechanism. Let me quote the bottled water incident again. If we only detect the problem 6 or 9 months after the fact, is it the case that we can still trigger the Tier 2 investigation? Secretary. In the regulation, we do not rule out triggering Tier 2 investigation against incident that happened before the 17th of July 2026. So naturally, we mean to say that incidents happen before and after the commencement date can be investigated by the investigation team under the PSC. Well, I think that we should put this in record. I think that the response of the administration is important. Sometimes the incident happen after the problems have been there for a while. So, well, The reason why we have this commencement date is that after the date the investigation team of the PSC will be empowered to investigate. It has nothing to do with when the incident happens. Mr. Tan Kap-yu. Has there been any incident that have happened and you're aware of it and that you're waiting to trigger this Tier 2 investigation after the 17th of July 2026 to investigate into it? Secretary. There's none, because if we are aware of any problems, we launch investigation into it immediately. Some members have asked me about the Wenful Court. As I said, we have to wait for the report of the independent committee. We need to see if they are holding any civil servants liable in the report. If we are aware of any problems, we investigate into it. That's it for Clause 1. Clause 2, interpretation. In this regulation, we define investigation team in Clause 2. Any questions? None. Clause 3, referral of problems for investigation. If a problem occurs in the government and it meets any of the conditions specified in subsection 3A, B, and C, any of the following persons may refer the problem to the Commission for investigation: the Chief Executive, a Secretary of Department, a Deputy Secretary of Department. And with the agreement of Chief Executive, Secretary of Department, and Deputy Secretary of Department, then the problem may be referred to the Commission for investigation. Subclause 4. Chief Executive, Secretary of Department, Deputy Secretary of Department need to set terms of reference for the investigation, and they may revise the terms of reference at any time before the investigation begins or during the course of the investigation. Mr. Lam Chen-sing. Many members asked about the investigation time frame. I don't have a particular opinion on that, but I have questions regarding the operation of the investigation. Will the Chief Executive or Deputy Secretary of Department or Deputy's SOD set a time limit for investigation? Say, for example, will they ask the investigation team to complete the investigation within 3 to 4 months, and will they make public the investigation time frame on their website, for example? Secretary, yes, we will do that. Ms. Carmen Khan. Madam Chair, on referral of problem for investigation, Secretary of Department, Deputy Secretary of Department are mentioned. I have questions regarding their translation. Is the Chinese translation of Secretary of Department Xi Zhen and Deputy Secretary of Department Fu Xi Zhen and Director of Bureau Fu Guk Zhen? It seems different from what the terms we use daily. Well, the definitions are set out in the basic law. Any questions? So is there a definition for secretaries and deputy secretaries in the principal ordinance or section 3B of Cap 93? And it's not defined in Cap 1 either. How do we make sure that the translation is consistent? Perhaps I ask the legal advisor to explain it. Thank you, Madam Chair. As the Secretary said, the terms and titles are used in the basic law. We're just using what's used in the basic law, I don't think that we need to define them specifically. I don't think that the articles in the basic law is directly applicable to the laws of Hong Kong. I think that you need to define Secretary of Department in the laws of Hong Kong. That the translation of Secretary of Department is the Chief Secretary of Administration. Who are the Secretaries of Department? Madam Chair, am I clear enough? Because definitions used in, terms used in the basic law may not be directly applicable to the laws of Hong Kong. Legal advisor, please.
As the officer from the Department of Justice said, we're adopting the language in the basic law. There should be no uncertainty. Of course, greater clarity is always welcome, but I think the regulation as it stands now will not give rise to misunderstanding. On what basis do you say there will be no misunderstanding? When the matter reaches the court looks at the law, and they will look at whether the definition in the basic law applies to Hong Kong's legislation. We will need a legal basis. A written reply will be fine with me. Now, I also want to make another point. Ms. Khan referred to Director of Bureau. We use this term all the time in internal government documents. So we don't set out the names of every Director of Bureau. We refer to these officers as Directors of Bureau as a collective term. Can you revisit this point? I don't see anywhere in Hong Kong's legislation adopting this term. You have to show us that what is defined in the basic law applies directly to Hong Kong's legislation. We can revisit this point with the legal advisor, and then we will provide a written reply. Section 4. Commission must conduct investigation on referral. So once a referral is received from the chief executive, an SOD, a DSOD, or DOB, the Commission will have to investigate a matter subject to the scope of the terms of reference. Questions? If not, we will proceed. Ms. Carmen Khan. Can the Bureau tell us? Again, this goes back to the question of the legal advisor. Can I backtrack a bit? I didn't know we were going into Section 4. Section 3 says, if there is a sign that the heads of department or the permanent secretary may be implicated. Now, it's clear with the permanent secretary. But when it comes to the head of department, and the legal advisor asked a question about the head of organization. Under the Ombudsman Ordinance, there's a definition for the head of department, but the Bureau thinks we don't need such a definition. That's fine, but can you give us a list? A list of all the heads of department and permanent secretaries. Can we have a list? Or is a list readily accessible on government website? Secretary, yes, people can find that on the government's website. Now for heads of department, say the head of the civil service aid, they have a chief officer. People can find that information online. We also have a standing committee on the pay and standing and conditions for the civil service. There's a Secretary General. All that information is available online. Ms. Khan was looking for a full list. You were saying people can find the information on each website. Do you have a single list with all the information. There should be such information online. Let's move on. Section 5. Formation of the investigation team. This investigation team will consist of the chairperson of the commission plus at least one member. If the member is out of town or is unable to act for other reasons, the PSC chairperson can follow Section 5, Subsection 3 of the regulation by getting another PSC member to stand in for the member who is unable to act or replace that member. Mr. Lam Chen-sing. I have a question about who will serve on the future investigation team. Other statutory teams have a similar way of operating. There are maybe 10 members on the full team, but only 3 members will perform the functions. Usually, these details are set out in the ordinance. Say for occupational safety and health, there will be 1 member representing the contractors. There's another member representing workers. So my question here is that will there be administrative guidelines to set out with greater clarity why we're picking a certain member? What are the principles? Will there be greater clarity on the administrative arrangement? Secretary. Here, neither the chairperson nor the member of the PSC is a civil servant. They are independent. Every time when there is an investigation, we look at the complexity and the expertise needed, and then the PSC chairperson finds the right PSC member. That will offer greater flexibility. We don't want to box in the PSC's operation. People on the PSC are independent individuals. Of course, they have their own professional background. We do not specify the professional background. So we cannot specify that at an administrative level. So we decide to leave this matter to the PSC chairperson, Ms. Carmen Khan. Are there requirements? Say, is there a quorum for the investigation team under the PSCO? Section 3 of the PSCO, Section 3, Subsection 1, has this to say: the PSC is made up of 1 chairperson plus 2, somewhere between 2 and 8 members. You can have fewer members, but you cannot go below 2. That's the PSCO on the formation of the PSC. So we should review the PSCO to make sure it is up to date. When we give the PSC more powers and responsibilities, we may need more members, because here the regulation says when the PSC member is out of town or is simply unable to act. We may have to define what it means by being absent from Hong Kong. What do we mean by being unable to act? Of course, we can exhaust all the examples. The regulation is drafted in line with the PSCO, because the principal legislation also says when this member is unable to act or absent from Hong Kong, the CE can take certain actions. The language of the regulation is in line with that of the PSCO. But if you have a cap on just 8 members on the PSC, then we should keep an open mind about reviewing the PSCO. I believe that's noted. Let's move on with the scrutiny. Functions of the investigation team. The investigation team can require a person to hand over any information or document in that person's possession. Second, giving the investigation team access to any information or document in that person's possession or under their control, and to explain the matter upon the investigation team's request, and also meeting with the investigation team and answering questions in writing, and giving all other forms of assistance to the team. The investigation team can also inspect, reproduce, and take over any information or document that is given, or take extracts from such document. The team can also enter and inspect any premises occupied of the government or any other premises with the consent of the occupier of the premises to help the team understand the problem and the cause of the matter. The investigation team can also appoint any one person, meaning a supporting staff member or expert, to assist in the investigation, and also delegate functions to the appointed persons. Questions? Ms. Carmen Khan. I have a question about where these functions come from. We're talking about internal investigations that will be handed over to the PSC for greater credibility. So the functions of investigation should be comparable to the existing internal investigations. The persons who are investigated may be civil servants, but also non-civil servants. So anyone can be investigated, and this person does not have to be the civil servant under investigation. So that's the question of who. And here we're not talking about summoning a person or obtaining a court warrant. This is purely internal investigations conducted on a best effort basis. Serving civil servants are expected to cooperate with the investigation, and that's the thinking behind the drafting. So the functions here are not as strong as we normally think of. The functions here are performed on a best effort basis, so there's nothing compulsory. This is not a judicial process, is that correct? Madam Chair, that's correct. We conduct internal investigation too. At the moment, we simply appoint a more senior civil servant who has nothing to do with the matter to look into the matter. In the future, that investigation will be conducted by the independent PSC. We're not trying to imitate law enforcement agencies in their investigations. We don't want the investigation to be a judicial process. Mr. Wu Yingpeng. Thank you. During an investigation, information will be seized. That will be inevitable. That information may cover personal data, trade secrets, or the information of third parties. My question is, after the investigation, what do we do about the information? Would that be destroyed, returned, or sealed for good? Secretary. Replicating information is easy. I believe replication will be the most common approach. If departmental files are involved, the files will have to stay there. We cannot permanently remove those files. After the investigation, a report will be submitted. The department involved will have to look at the report and the evidence used during the investigation, because the department involved may have to proceed to disciplinary hearings. The files will become evidence for the hearings. So the files cannot be destroyed. After all is said and done, government department have to follow time limits on the retention of files. After a while, if they see the need to destroy the files, they can arrange for such destruction. The Secretariat of the PSC, so I'm talking about the Secretariat, is also part of the government. They will stick to the same rules about file retention.
文員
Ms. Carmen Khan. Madam Chair, I have a follow-up question. The terms of reference of the investigation team is their power. But for other involved persons, well, for PSC investigation team, they have the power to enter government premises. But in the regulation, we do not ask the managers of government premises to cooperate. The powers conferred to the investigation team is far lower than that for the law enforcement agencies. I think that the functions of the investigation team of PSC is rather lacking or weak. If we have to make amendment, then we have to amend the regulation. Is there any way for us to make improvement without amending the regulation? Because we're just trialing out this Tier 2 investigation. Is there any way for us to make adjustment without amending the entire regulation? If the PSC chairman or members want more power to conduct an investigation, is there a catch-all clause for them to do that? Thank you. Secretary. In Regulation 6, we say that a PSC can require any person to produce or to offer assistance in connection with the investigation that include answering questions, allowing entry to certain premises, so on and so forth. Through administrative means, we can achieve what the member said. Say, for example, if a civil servant is uncooperative, if we want to enter certain government premises, we ask all colleagues, including managers of all premises. Well, they would be civil servants if we're talking about government premises. They will need to cooperate. That much is very clear. So it's impossible for managers of government premises to reject a PSC investigation team to enter it. We do have a very clear set of internal guidelines and requirements as well as instructions for us to achieve our goals. I have a question. Just now, Ms. Carmen Khan asked about government premises. 61C2 talks about entering and inspecting premises occupied by the government. It is said that with the consent of the occupier of the premises or owner of the premises, investigation team can enter and inspect it. Do we need a written consent or verbal consent? Can you clarify the definition? Secretary, thank you. We want to offer greater flexibility to the investigation team. Well, depending on the extent of entry, depending on the owner of the premises or occupier, they can give consent in various ways. Some owner or occupier may be more cautious. They may require a written application for entry. Some may be more easygoing. They may just grant a verbal consent. We want to allow for greater flexibility. Depending on the preference of the occupier or owner of the premises, they can give consent in ways they prefer. So the owner or occupier may give verbal consent, but sometimes you may not be able to identify the owner of the premises. The security guard of the premises may grant investigation team entry to the premises. They may not have the power to grant entry. Well, under such circumstances, are we breaching the personal data privacy ordinance? Secretary. Madam Chair, the investigation team can only enter and inspect a premise if the owner or occupier of the premises grant consent. There is a certain level of safeguard here. Second, the PSC is not going to conduct random or surprise inspection. They will make arrangement in advance of that. And I believe that in the process, they will be able to identify the true occupier or owner to obtain a consent from them. Ms. Carmen Khan, can I ask about 1D2? Are we past that? I was talking about 6D, 61D, about the appointment of any person to assist in the investigation. Can I ask questions about that? Does the PSC have powers to hire any person or pay remuneration? Because if we're talking about appointment, they may appoint overseas experts. Does the PSC have the power to engage experts by paying them remuneration? Second, D2 talk about transfer of power or delegate of power. How should we understand it? Thank you. The PSC has the power to engage supporting staff by paying remuneration. We understand that we may sometimes need professionals to offer advice, and they may require rewards for their opinion. Second, regarding delegation of power, well, first of all, the PSC will have to appoint someone first, and sometimes the appointed person may delegate part of their power. They need to clarify what powers is conferred onto the delegated person. Regulation 7, conduct of investigation. It provides legal basis for the investigation of the team under PSC. 7(1)(3) says that the investigation is to be conducted in private. Because we're talking about an internal investigation, as PSC and the investigation team are not judiciary organization, no hearing will be convened. No counsel or solicitor has any right of audience before an investigation team, but a counsel or solicitor may appear before the team as the team considers appropriate. The person involved may also make oral or written statements. Regulation 7(4) says that no counsel or solicitor has any right of audience before an investigation team unless the team thinks it's appropriate. 7(5) says that if at any time during the course of investigation, the investigation team considers that there may be sufficient grounds for it to make a report or recommendation that may criticize or adversely affect any person, the team must give an opportunity to the person, or if the person or organization, to make an oral or written representations about the report or recommendation. Well, time is almost up. There are still some members who want to put questions. I'll extend the meeting by 5 more minutes or 15 more minutes. Mr. Lam Chen-sing. I have a comment. Regarding subregulation 4, the administration has already explained that under certain circumstances, the team may allow a counsel or solicitor to appear before the team. But I hope that the relevant regulations will not be strict. I understand that the counsel and solicitors may not have too much of a role to play during the course of investigation, but for the defendant, they may feel more safe with the presence of a counsel or solicitor, because after the investigation is completed, the disciplinary mechanism may be triggered. Well, you said that during hearing, counsel and solicitor may represent the defendant. But with the presence of a lawyer, it may facilitate the defendant in understanding the entire incident. I hope that the government will be more lenient in this regard. Secretary, I note the comment. Ms. Carmen Khan. Madam Chair, regarding bracket 4, I hope that the administration will explain further. In the English version, I understand it. It says right of order, right of audience. But in the Chinese version, it is said that the counsel or solicitor does not have the right to speak before the investigation team. But so by just reading the Chinese version, it may seem that the counsel or solicitor can appear before the investigation, only that they don't have the right to speak. The civil servants under investigation, do they have the right to bring a lawyer before the investigation team? I understand that in the English version, but in the Chinese version, that is not that clear. When we discussed the policy areas, the administration explained that the investigation is only internal. The civil servants need to cooperate because that's their duty. It's a fact-finding process. If it so happens that the civil servants want to resign, such that no investigation can be launched against them, because there may be misconduct involved, when a civil servant resigns, does the PSC still have the right to investigate into that person? Secretary. Regarding the Chinese version of Regulation 7 Bracket 4, it is said that if the investigation team considers appropriate, the counsel or solicitor may appear before the team. I was talking about the sentence before that. It says the counsel or solicitor does not have the right to speak before the investigation team. How should we understand this? It says, well, whether or not the lawyer can attend the meeting with the investigation team, we will have to read the entire paragraph together. The counsel or solicitor can only appear before the investigation team when they consider appropriate. Can the DOJ explain it? Thank you, Madam Chair. The Secretary was right in her interpretation. The English version, rights of audience, we fully understand what that means, but if we read the Chinese version, it says that the counsel or solicitor does not have a right to speak before the investigation team. That's the direct translation of right of audience in English. Madam Chair, if we read the English version, it says no counsel or solicitor has any right of audience before investigation team. But a counsel or solicitor may appear before the team as the team considers appropriate. How do we understand this sentence? Is it the case that only when the team deems appropriate, the counsel or solicitor can attend the meeting with the investigation team, and when they attend the meeting, they have the right of audience? Is that the case? The DOJ, can you explain in greater detail. By having no right of audience, it means that the counsel or solicitor have no right to appear before the investigation team. But if the team thinks appropriate, they may appear before the team. But as the team allow them to appear before them, they will be allowed to speak.
主席嚇呢
I think the drafting can be improved, so that's a suggestion for the government to study. Now, on the point about resigning, for a civil servant who resigns after the disciplinary procedure starts, then there will be suspicion that this worker is trying to evade the procedure. This person can still resign. For a civil servant on pension terms, the pension can be withheld. For civil servants on CSPF terms, now for those who stay on the job for more than 10 years, the civil servant will be entitled to the government contribution. We will be able to dock that part of the contribution. And if this civil servant has left, we will be able to recover the sum through civil action. During the investigation, if the civil servant resigns, we will not be able to prevent the civil servant from resigning, but the investigation will continue. The investigation is about finding out what has happened and who's responsible. Will get to the bottom of it. If the investigation happens and then halfway through it, the civil servant under investigation resigns, the investigation continues. When the civil servant resigns, the employment relationship is terminated. The government will no longer be in a position to ask the person to give evidence. The reply highlights my concern. This person may have to give notice for 3 or 6 months, or maybe this civil servant is dismissed through the summary channel. Can our investigation mechanism handle that? Now here we're talking about the conduct investigation, so we're talking about doing the investigation. Today we talked about the time frame of investigation. Under Section 7, there are 5 subsections. I think these 5 subsections are not complete enough. Can we enable the PSC to set the rules that will apply to the investigation? Otherwise, the investigation team looks at these 5 subsections. Do the investigation team make their own rules, or will the Secretariat lay down the rules? The PSC will have in place an internal procedure. Once this regulation takes effect, the PSC will come up with their internal investigation procedures, which will be the basis for the future investigations. So the PSC will come up with those guidelines. Maybe the PSC has the power to draft the rules under the PSCO, so maybe we will have to look at whether the PSCO empowers the PSC to set those rules. Madam Chair, we will revisit this point. We'll look into it then, and then we will provide a written explanation. Section 8, Investigation Report. Upon completing an investigation, the investigation team will have to prepare a report of its findings and advice, and then submit the report to the Chief Executive, the SOD, the DSODs. No question, let's continue. So that's all. So that completes the scrutiny, Ms. Carmen Khan. During the policy discussion, we talked about the difference between this investigation report and the Ombudsman's report. Why not write that into the regulation? Why not say why not be explicit that the report may or may not be made public? Why not make that explicit in the regulation? Or is it because that it is not for the PSC to make public the report? It's a matter to decide for the person who referred the matter, which may be the chief executive, maybe the SOD. So the PSC simply investigates and prepares the report, and then the job is done. Whether to decide whether to publish the report and how much of the report to make public will be for the officials to decide. Secretary, that's correct. The PSC will simply investigate and then submit the report to the principal officials who started the investigation. Whether to publish the report and how much of it to publish will be for the principal officials to decide. So we have concluded the clause-by-clause scrutiny. So maybe the legal advisor can look at whether there are drafting or legal issues in the text and whether there are issues with the English text. Aside from the issues we highlighted in our letter, raised in the letter on the 1st of June, and the government has responded to those points, other than those points, we have spotted no other legal or drafting issues. On the English text, we have not spotted any discrepancy. Now, if members wish to propose amendment to the regulation for the subcommittee to consider, please get your proposed amendment in by Monday, the 15th of June, and please submit the English and the Chinese text. If the government proposes to amend the regulation, please also get your draft amendment in by Monday, the 15th of June. Subject to members' views, we will decide whether to hold another meeting, or maybe we can circulate the documents to consult members on the draft amendment. To allow the subcommittee enough time to make a report to the House Committee, I will move a motion at the Council meeting on the 17th of June to extend the scrutiny period of the subsidiary legislation to the 15th of July this year. If we extend the scrutiny period by resolution, the timetable will be as follows. The expiry of the scrutiny period will be the 15th of July, the deadline for reporting to the House Committee on the 3rd of July, the deadline for giving notice to amend the regulation, the 18th of July. Any other comments? If not, I will adjourn the meeting here. Thank you.